Criminal Law Revision. Intention. Intention is called dolus in Latin. Intention is to know and will an act or a result. In other words, a person acts with intention if he has the will to act or achieve a result where the person knows that what he is doing is unlawful. There are three different types of intention: direct intention, or dolus directus in Latin, indirect intention, or dolus indirectus in Latin, and dolus eventualis. The test for intention is subjective. Here the courts will look at what the accused thought. Take note that motive is irrelevant. Dolus directus. A person acts with direct intention if his initial goal was to achieve the forbidden result. For example, X wants to kill Y. He shoots him and Y dies. With dolus indirectus, it is not X's goal to cause the forbidden result, but in order to achieve his main goal, his conduct will have to cause the forbidden result as well. For example, X wishes to steal a famous painting from his neighbor's house. This is his direct intention. But in order to get the painting, he has to break Y's window. Therefore, we can see that when breaking the window, he has dolus indirectus, or indirect intention. Dolus eventualis. A person acts with dolus eventualis where it is not his goal to cause the forbidden result, but he foresees the possibility that when taking action to achieve his main goal, he might cause the forbidden result, and he reconciles himself with this possibility. Note, the examiners will look for the words highlighted in blue. Make sure you use these exact words when discussing dolus eventualis. Let's look at some case law. In Jolly, X wanted to derail a train as an act of sabotage. He knew that people could die from such an act. However, he still chose to go ahead. He cannot say that he did not intend to kill people. His intention is present in the form of dolus eventualis. In the case of Nsele, X and Z decided to rob a bank. X drives the getaway vehicle. X knows that Z is armed and may use the weapon. Y, the shop owner, resists the robbery. Z shoots and kills him. Both X and Y are guilty of murder. X had intention in the form of dolus eventualis. Note that in order for dolus eventualis to be present, X must actually foresee the possibility and reconcile himself with that possibility. It is not sufficient to say that X should have foreseen the possibility. Mistake. A material mistake takes away intention. The courts use a subjective test when establishing intention, and therefore they use a subjective test when establishing a mistake. This is because a mistake negates intention. A material mistake. Let's look at an example of a material mistake. X goes hunting. He shoots what he thinks is a buck, but it turns out that he actually shot a person. X made a mistake with regards to what he was shooting. The definitional elements for the crime of murder are as follows. Murder is the unlawful, intentional killing of another human being. Here, X did not have intention to kill a human. He thought that he was killing a buck, and therefore he made a material mistake. This kind of mistake is an error in objecto. X will not be guilty of murder. However, the court might still find him guilty of culpable homicide. Let's look at a non-material mistake. X wants to kill Y. He knows that Y lives alone and that Y takes the rubbish outside every evening at 8 p.m. He waits outside Y's house. He sees a person emerge from the house at 8 p.m. with a bag full of rubbish. He aims and shoots the man. It turns out that he shot Y's brother, who had come to visit and had taken out the trash as a favor. X made a mistake with regards to who he was shooting. This is an error in objecto. The definitional elements for the crime of murder are as follows. Murder is the unlawful, intentional killing of another human being. Here, X intended to kill a human, and X did kill a human. Therefore, X made a non-material mistake, and X is guilty of murder. Mistake in the chain of causation. Remember, causation only applies to materially defined crimes. These are result or consequence crimes. Prior to the case of Goosen, this form of mistake did not exclude intention. In the case of Goosen, X, Z, and W robbed Y. While robbing Y, a car backfired, which gave Z a fright. Z shot at Y, and Y died. X drove the getaway vehicle and knew that Z had been armed. He knew that Z might use the gun and still chose to go ahead with the robbery. The court had to determine whether X still had dolus eventualis because he had not imagined that Y would use the gun as a result of getting a fright from a car backfiring. The court held that there was a substantial difference between the actual and the foreseen way in which Y's death was caused. Thus, X was found not guilty of murder. In the case of Lungile, X, A, and B robbed a shop. Z, a policeman, tried to stop the robbery. He fired shots at the robbers and they returned fire. Y was killed in the crossfire. X argued that the actions of Z constituted a novus actus interveniens, and therefore X was not the legal cause of Y's death. The court rejected this argument. The question arises, could X have succeeded if he relied on a mistake as to the causal chain of events? Unisa feels that he would not have succeeded as there was not a substantial difference between the foreseen events and the actual course of events. Aberratio ictus. Aberratio ictus is not a type of mistake. Aberratio ictus occurs when a person misses their target and they kill somebody else. For example, X puts poison in Y's glass of champagne. Y doesn't drink it and instead offers it to Z. Z drinks the champagne and dies. Another example, X aims towards Y and fires a shot. The bullet hits a stop sign and ricochets. It hits Z instead and Z dies. There are two different views regarding the aberratio ictus: the transferred culpability approach and the concrete figure approach. According to the transferred culpability approach, X wished to kill a person. The fact that he killed the wrong person is immaterial. The intention to kill one person is transferred to the person whom X actually did kill. The concrete figure approach. The courts must apply the ordinary principles of intention. X can only be guilty of killing the wrong person where he has dolus eventualis. In other words, he must have foreseen the possibility that he may kill somebody else and still have gone ahead. In the case of Unisa, the court followed the concrete figure approach. Unisa prefers this theory because it is more in line with the subjective test applied when determining intention. It is also in line with the decision taken in the case of Bernardus to reject the Vasari doctrine. The judgment in Unisa confirms the following. X will be guilty of attempted murder in respect of Y, whom he actually intended to kill. If X foresaw the possibility of killing another person and reconciled himself to this possibility, he will be guilty and have intention in the form of dolus eventualis. If X lacked dolus eventualis, he may still be held liable for culpable homicide if the requirements for negligence are satisfied. Let's compare a mistake, an error in objecto, with aberratio ictus. Let's look at the material mistake. For example, X goes hunting. He shoots what he thinks is a buck, but he actually shoots a person. X made a mistake regarding what he was shooting. Here, he did not have intention to kill a human being, and therefore X is not guilty of murder. With aberratio ictus, a person will miss their target. Here, X goes to Y's house at dusk. He sees a figure which he believes to be Y's horse. He shoots at the horse. The bullet misses the horse and hits a stable boy, Z. X did not have direct intention to shoot Z. This is an aberratio ictus because the bullet struck an object different from the one at which X was aiming. Now the question is whether X had dolus eventualis. If he foresaw the possibility that he might miss and kill somebody else, he will be said to have intention in the form of dolus eventualis, and he will be guilty of murder. If he did not foresee this and did not reconcile himself to that fact, X will not have dolus eventualis and will therefore not be guilty of murder. Let's look at a non-material mistake versus aberratio ictus. With a non-material mistake, X did not miss his target. He saw a person and aimed at that person. He fired his gun and killed that person. However, it came to light afterwards that he had killed the wrong person. Here, he did have intention to kill a human being, and he did kill a human being. Therefore, X is guilty of murder. With aberratio ictus, X is shooting at the horse, but he misses and hits the stable boy. Here, the court will need to determine whether X has dolus eventualis. If he does, X will be guilty of murder. If he doesn't, X will not be guilty of murder. In summary, with an error in objecto, X does not miss his target. He just made a mistake regarding the identity of the object. In a case of aberratio ictus, X will miss his target. Let's look at mistake relating to unlawfulness. Here, a person thinks they are acting with a ground of justification. This will be a putative defense and will not hold. In the case of Joshua, Y forgot his keys at home one evening. He climbed in through an open window. His wife thought that he was an intruder and killed him. She thought that she was acting in private defense. But the test for private defense is objective. Factually, she was not in danger, and therefore she was not acting in private defense. This is a form of putative private defense, and this is not a valid ground of justification. However, she did not have intention, in other words knowledge, that she was acting unlawfully, and therefore she made a mistake as to a ground of justification. Let's look at another case of a mistake relating to unlawfulness. In the case of Sam, X was charged with pointing a firearm at Y. X had pointed the firearm at Y, believing Y to be a thief. Y was not actually a thief. X thought that he was acting lawfully by capturing the so-called thief, and therefore he made a mistake as to a ground of justification. He therefore lacked intention, and therefore we can see that a mistake relating to unlawfulness negates intention. A mistake of law. In some cases, a person may not know that his or her actions are regarded as a crime. Prior to 1977, South Africa followed English law. Everyone was presumed to know the law, and therefore ignorance of the law was not a defense. This position was also followed in South Africa. The case of De Blom. At the time of this case, it was a crime for a person to take more than 600 rand worth of jewelry out of the country. The accused stated that she had not known that this was a crime. The Supreme Court of Appeal held that ignorance of the law is a valid defense because it excludes intention. The De Blom case was criticized. Certain jurists feel that ignorance of the law should only be successful where such ignorance is reasonable. Negligence. Negligence is called culpa in Latin. The test for negligence is objective. Here the courts will look at the actual facts. The court uses the reasonable person test. A person's conduct is said to be negligent if a reasonable person in the same position would have foreseen the possibility that the particular circumstance might exist or that his conduct might bring about a particular result, and that reasonable person would have taken steps to prevent such a possibility, and the accused did not take those same steps that the reasonable person would have. In summary, we can say that the reasonable person test is the following. The reasonable person would foresee the possibility and take reasonable steps to prevent it. In the case of Duma, X was charged with unlawfully possessing a firearm. X said that he had picked up what he had thought was a toy gun. The question before the state was whether X had acted negligently. The question was whether a reasonable person would have thought that the gun was a toy. The court held that X was not negligent, and he was therefore acquitted. So what is a reasonable person? Here we need to look at two things. Number 1, reasonable foreseeability. It is important that the possibility was foreseen. Whether the result or circumstance was likely or not is irrelevant. The court will assess the reasonableness of X's actions in according with the circumstances in which he found himself at the time of acting. For example, if X knocked down a pedestrian during a storm at night, the court will not test his actions against a reasonable person driving during a sunny day. Number 2, reasonable steps which the reasonable person would have taken. Where the reasonable person foresees a certain possibility, he may take steps to safeguard against such a result. There is an exception to this rule. Sometimes a person may foresee a possible result, but may not take steps to safeguard against it. This may happen when the possibility is extremely unlikely or far-fetched, and the cost and effort required to prevent the possibility is extreme, and the risk of the possibility occurring is very slight. Although the test for negligence is objective, sometimes subjective factors play a role. For example, when testing the conduct of a child, the court will look at the actions of the reasonable child. When testing the conduct of an expert, the court will look at the actions of the reasonable expert. Negligence and intention. If X is charged with culpable homicide, and it turns out during the trial that he actually had the intention to kill Y, can he still be found guilty of culpable homicide? In other words, we need to look at whether the concept of intention can include the concept of negligence. The answer is yes. In the case of Ngubane, the court held that while negligence and intention are two different concepts, it would be incorrect to assume that proof of intention excludes the possibility of finding negligence. This means that even if X is found to act intentionally, one can also say that he acted negligently, as his conduct did not agree with the standards of a reasonable person. Negligence and private defense. A person can exceed the bounds of private defense. In the case of Ntuli, X argued with an older woman. He struck her on the head and she died. The court held that X had exceeded the bounds of private defense. X was convicted with culpable homicide. The appeal court confirmed this ruling. We have now come to the end of criminal law for persons taking CRW 1501. Good luck with your exam. If you are taking CRW 2601, you will now need to continue watching the video with intoxication. Intoxication. Intoxication may cause a person to act in a manner that they would not normally act in. We have two types of intoxication: involuntary intoxication and voluntary intoxication. With involuntary intoxication, X does not choose to drink the alcohol, and therefore X is not liable. With voluntary intoxication, X chooses to drink the alcohol. There are three types of voluntary intoxication: actio libera in causa, intoxication resulting in a mental illness, and intoxication in general. With actio libera in causa, X wants to commit a crime. He deliberately drinks to give himself courage. Here, the alcohol is an instrument. With intoxication resulting in a mental illness, we will follow the normal rules for mental illness as set out in Section 78 of the Criminal Procedure Act. With intoxication in general, there are two approaches: the lenient approach and the unyielding approach. Today, we follow the lenient approach. Prior to 1981, the courts followed the unyielding approach. This was in line with our common law. The courts used the specific intent theory. According to this theory, intoxication could exclude a specific intention and replace it with ordinary intention. This was held in the case of Fowley. For example, where X had the specific intention to murder Y, intoxication will negate the specific intention, and X will only be charged with culpable homicide. Where X had the specific intention to inflict grievous bodily harm to Y, intoxication will negate this specific intention, and X will only be charged with ordinary assault. This theory is criticized. How can intoxication take away a specific intention and not ordinary intention? If a person is so intoxicated that they cannot formulate a specific intent, how can they formulate any intent? In 1981, we had the leading case of Chrétien. In the case of Chrétien, X was intoxicated and drove into a group of people. One died and the others sustained injuries. X was charged with murder in respect of the person who died, and with attempted murder in respect of the others. X's defense was that he had thought that the people would move out of the car's way. He did not intend to kill or injure anyone. Due to X's intoxication, he could not be convicted of murder under the specific intent theory, and therefore X was convicted of culpable homicide. X could not be convicted of attempted murder because he lacked intention. However, the question before the court was whether X could be found guilty of assault on the charges of attempted murder. Both the trial court and the appeal court held that X could not be found guilty of assault. As a result of Chrétien, intoxication may exclude a voluntary act. This is the same as sane automatism. it may exclude criminal capacity, and it may exclude intention. As a result of Chrétien, intoxication was also recognized as a complete defense. This case has been criticized. The decision in Chrétien meant that drunk people were treated more leniently than sober people. Drunken people should not be allowed to use intoxication as a veil to hide behind when committing crimes. In a reaction to this criticism, Parliament passed a provision which was aimed at preventing an accused from easily escaping criminal charges on the basis of intoxication. This provision is called Section 1 of Act 1 of 1988. According to Section 1 of Act 1 of 1988, we have the following different degrees of intoxication. Slight intoxication does not take away the voluntariness of an act, and it does not exclude criminal capacity. But slight intoxication does exclude intention. Note that this form of intoxication is only relevant as a defense in crimes requiring intention. B. Medium intoxication. This does not take away the voluntariness of an act. It does, however, exclude criminal capacity. And C. The strongest degree of intoxication. This does take away the voluntariness of an act. With this form of intoxication, X is so drunk that he cannot even perform a voluntary act. Section 1 of the Act states that any person who would be declared not criminally liable as a result of voluntary intoxication will still be guilty of another crime, namely, a contravention of Section 1 of Act 1 of 1988. This Act creates a new offence. The punishment for contravening the Act will be the same as the punishment that the accused would have received had he been found culpable. Let's look at the 7 elements of the crime which is created in Section 1 of the Act. The consumption or use of a substance by X which impairs his or her capabilities to such an extent that he lacks culpability. Here, X must know that the substance has this effect. These 4 elements are the elements dealing with the consumption of alcohol or narcotics. Number 5. X commits a prohibited act which is punishable by law, while he lacks criminal capacity, and because of this lack of criminal capacity, he is not criminally liable. These are the elements dealing with the prohibited act. Note, Section 1.1 of the Act uses the word substances. This applies to both alcohol and drugs. The crime created in this section is unique because it is the only crime where the state must prove that X lacked criminal capacity. The effect of Section 1. Section 1 does not apply to cases where intoxication only excludes intention. It does apply to cases where intoxication excludes criminal capacity, and it does apply to cases where intoxication negates the voluntariness of the act. Therefore, persons who are intoxicated only to the extent which excludes intention will be afforded the defense allowed in Chrétien. Therefore, we can say that intoxication will be a defense against any crime requiring intention. We can see that our court's approach to intoxication has changed over time. This change in approach can be compared to a swinging pendulum. The courts moved from an unyielding approach to a lenient approach and back to an unyielding approach. Intoxication and culpable homicide. Where X is charged with murder and is found not guilty on the basis that he lacked intention due to intoxication, as held in Chrétien, then X will almost always be convicted of culpable homicide. This is because he negligently consumed excessive alcohol, which resulted in his act. This conclusion can be reached without using the specific intent theory. Although, if you use the specific intent theory, you would result in the same conclusion. Intoxication and punishment. Intoxication can be a mitigating factor during sentencing, but it cannot mitigate a sentence where intoxication is a definitional element of the crime. For example, the crime of driving under the influence of alcohol. This was confirmed in the case of Calder. Where a person deliberately consumes a substance to commit a crime, in other words, actio libera in causa, the intoxication will not be a mitigating factor. In fact, it will be an aggravating factor. Please now learn Chapter 12 and Chapter 13. Be sure to focus on strict liability and the case of the bee in a cool drink bottle. Also take note of the Vasari doctrine and the criminal liability of corporate bodies. Let's look at a summary of criminal liability. When dealing with a question in the exam, you must identify which element you are dealing with: an act, the definitional elements, causation, unlawfulness, or culpability. You need to address all of the law under that section, as well as the case law, before summarizing up your opinion in answer to the actual question. Do not mix the different sections. Make sure you are working with what is being asked. We have now reached the end of our revision for criminal law general principles. Good luck for your exam. We hope you do well.